Hello and welcome to this presentation about data protection and how it is relevant to Rotary. All clubs must comply with the Data Protection Act when handling personal information. They might not require to be registered with the Data Commissioner, but it is worth checking that the information being kept does not require future registration. There are 8 principles regarding data protection. This presentation will go through them and show where they may apply in regard to Rotary activities. Data must be handled fairly and lawfully, meaning you must have legitimate grounds for collecting and using the personal data. The information must not be misused or have an adverse effect on the individual concerned. You must also be honest about how the data will be used and provide advice if requested. Ask yourself, do you really need to know the age of one of your guests for a dinner event, or would less information be appropriate? What is this going to be used for? Personal data can only be gathered for specific lawful purposes and not used in any manner which is irrelevant to those purposes. If you do need the information for something else, you must obtain permission from that person. For example, a new insurance policy being taken out by the club might require information about health. You may know the answer from other information, but you will need to ask permission of that Rotary member first before disclosing it. If a third party asks for the phone number of a club member, you will need to ask that Rotarian for permission to share the information. Alternatively, you can ask if the Rotarian could contact the inquirer directly. Personal information must be relevant and not excessive in relation to the purpose. You may only need basic details. When assessing the information, consider how many people you have information for and what kind of information it is. More importantly, think about the consequences for the individual concerned if this is kept or deleted. Imagine you are organising a golfing event for club members. You may need health information just in case of an emergency. This information is only needed for those who are going on the trip, not those who are not attending. Accuracy of information is very important. If there is a mistake, this could result in insurance policies being invalid, health concerns not being recognised, or even a person being prevented from participating in an activity because it is wrongly thought that they have a criminal conviction. Even a wrong address could result in confidential mail being sent to the wrong place. It is your responsibility to ensure data is correct, can be traced back to the source, which should be the person concerned, and is up to date. Personal data should not be kept for longer than is necessary. In practice, this means reviewing the length of time personal data is stored. Think about why you have the information and whether or not it is still needed. If it is not needed anymore, it will need to be destroyed securely. Paper documentation may need to be shredded, not just put in the bin. Financial payment information can only be stored for 3 months, after which it must be destroyed securely. This would apply to all financial transactions, for example, district conferences, assemblies or trips. Bank details can be misused if in the wrong hands, which is why it must be destroyed. It could present a security risk if it is stolen or misplaced. When a person shares their personal information, they are trusting it will be used appropriately. They have a number of rights, including seeing a copy of the information, objecting to how it will be used, and asking for it to be corrected or even destroyed. If these rights are breached, the person can claim compensation for damages caused by breach of the Data Protection Act. The only exception to this could be if there was a record of a criminal conviction which could affect their progression within the club. For example, it would be necessary to keep this in case the Rotarian applies to the post of club treasurer. If there is a previous conviction for fraud, it may not be appropriate for this person to go forward for the post. The person can request that this is kept confidential. All information must be kept safely and securely to protect against accidental loss, destruction, or damage to the personal data. Make sure your security is fit for the nature of the data held. This may be the responsibility of more than one person, so be clear who is responsible for ensuring information security. There have been cases where hackers have succeeded in invading health organisation records to obtain personal information of patients. It may seem that a Rotary club is therefore an unlikely target, but hackers enjoy a challenge and are constantly looking for weak spots. These invasions go beyond scam emails and can result in identity theft. As well as being careful about who has the personal information, the Data Protection Act also states that data shall not be transferred outside the European Economic Area unless that country or territory ensures an adequate level of protection for the rights and freedoms of people in relation to the processing of the information. Essentially, this means the information will not be given away unless it is safe to do so and it is appropriate. For example, certain information about members may be shared between RIBI and RI because it is part of the same organisation and has appropriate security measures in place to ensure the transfer is safe and information is used correctly. Data protection is largely taking a common sense approach to the safety and use of personal information. Ensure clubs and districts understand their responsibilities with regard to the obtaining and storing of personal information. Further advice can be found on the Information Commissioner's Office website, which is www.ico.gov.uk. Thank you for watching.